Okay, good morning and good afternoon, ladies and gentlemen. Welcome to the panel session of AI PPI. The topic for today is about Beijing Treaty on audiovisual performances. And first of all, let's see the notice, the rules of housekeeping, please. Okay, two rules for housekeeping and questions to the panelists can be submitted via the Q&A box. You can find the Q&A box in the bottom of the Zoom screen. And for technical problems, please send us a message in the chat box. So there's you need understand the functions of the two boxes: Q&A box for questions and answers, and chat box for any other technical problems. Yeah, that's it. That's the rules for housekeeping. Let's go to the formal session of the panel. And as we know, WIPO member states in 2012 approved the treaty at a diplomatic conference hosted by the Chinese government in Beijing, from where the treaty takes its names. And the Beijing Treaty has officially entered into force on April 28, 2020, 3 months after Indonesia joined as a key 30th accession or ratification. And let me share my screen first of all. So, welcome everyone. I'm the moderator for this session, and I'm managing partner of Beijing TA law firm and chairman of corporate committee of AIPPI China Group. I focus my legal practice on copyright, media, and entertainment law. And first of all, we have our first honored panelist, Ms. Michele, to give her speech. And Michele is the director of the Copyright Law Division at the World Intellectual Property Organization. She leads the division in supporting WIPO member states in activities related to the WIPO Standing Committee on Copyright and Related Rights, as well as assisting member states with becoming party to and implementing WIPO copyright and related rights treaties and updating national copyright and related rights law. So let's welcome Michele. Michele, can you unmute your...
Thank you very much, Alan. And I well remember the Beijing Diplomatic Conference. It was a real highlight of my career here at WIPO so far. Unlike some of the other panelists, I'm relatively newer to these issues, having more or less started working on them in 2008. And I joined here at WIPO in 2012, and in fact, arrived in Geneva and was whisked off to the Beijing Diplomatic Conference 2 weeks later for a very intense but really exciting and uplifting diplomatic conference with an amazing support from the Chinese government and all of the organizers. Was really highlight an amazing time. And then, of course, this treaty was adopted. And the treaty, as I'm sure most of you know, is designed to protect audiovisual performers in audiovisual productions that involve sound and images, could be just images, like films, movies, videos, TV programs. And Before I got to the Beijing Diplomatic Conference and we had that amazing success, I can't take a lot of credit for it, but it was great to be there. I also want to remember back to 2011 when I was actually a delegate to the Standing Committee on Copyright and Related Rights at WIPO. And we were in an informal negotiating session for the Marrakesh Treaty, which followed this treaty, when some delegates came rushing in saying, we have to call the session, we have to call the session, we have agreement on what at that time was still the Audiovisual Performances Treaty. So we have agreement on the one term that had not been agreed in 2000 at a diplomatic conference. So 11 years later, through negotiations among member states and very much through the stakeholders, there was agreement on this famous 20th article, or what was turned out to be Article 12 of the Beijing Treaty. So I'm going to give a little bit of background on how we got there, looking at this in the framework of the WIPO copyright and related rights treaties. What you see on the screen before you is a little visual of the various copyright and related rights treaties and a timeline of that. So because we're here talking about related rights rather than copyright rights, we're looking at the treaties that relate to that, which start with the Rome Convention in 1961. And the Rome Convention when adopted in 1961, protected various related rights holders who are not the direct authors of works, but very closely associated with the works and have some rights in them, including broadcasters and phonogram producers, or also known as sound recording producers, as well as performers. And these could be performers both in audio, sound recordings or audio only works, or visual works or audio visual works. So in the Rome Convention, the performers did receive some rights. They received a right to prevent basically unauthorized communication or broadcasting of their works to the public, unauthorized fixing of their unfixed performances by, for example, capturing it on video, or other unauthorized reproduction or copying of their performances. However, there was also what we came to know as the cutoff provision, Article 19, which said if the performer has consented to the incorporation of a performance in a visual or audio visual fixation, then those rights have no further application. So this effectively meant that once an audiovisual performance is fixed in an audiovisual work, the performer had no further rights in that. That's perhaps a slight oversimplification, but the Rome Convention, for that reason, among other reasons, was not providing full rights to audiovisual performers. Then we get to the Internet treaties in 1996. These treaties were setting out to update the Berne Convention and the Rome Convention for the digital era and to cover, for example, transmission of programming over the internet, something that wasn't contemplated at the time the Rome Convention was adopted. So the Internet treaty that's of course most related to the Beijing Treaty is the WIPO Performances and Phonograms Treaty, has performances in the title. And this treaty addressed the situation of two of the three categories of beneficiaries of the Rome Convention, performers and phonogram producers, or sound recording producers. However, it did not address audiovisual fixations or the rights of performers in audiovisual fixations. So it updated a lot of rights for example, performers in sound recordings or unfixed performances, and for sound recording producers, but it did not cover the rights of the audiovisual producers, as well as, of course, the broadcasting organizations. That's another story that we don't have time to get into now, but that negotiation is actually still going on. So this treaty granted rights of reproduction, distribution, right of rental, and the right of making available to performers who were covered by the treaty. And then there was an agreement at that time that there should be continuing work on the updating of rights for performers. So skipping a lot of steps, in 2000, there was actually a diplomatic conference on the protection of audiovisual performances. And there was agreement on most of a text, 19 articles out of 20. The one issue that was not resolved was the transfer of rights from performers to producers, how that would be handled. There were different systems for that in different parts of the world, different existing systems, and there was no agreement on one system to apply. Now, others I know are going to speak a lot more about this, so I'm not going to get into a lot of detail about it, but we had the 19 articles. The treaty was not, the diplomatic conference was not concluded because there wasn't agreement on this one issue. It was left open for the future, and for the next 11 years was maintained on the agenda of the WIPO General Assembly. And finally, after it was announced in 2011 that there was agreement on this famous 20th article, which is Article 12, the standing committee, by consensus, adopted a text for that article, which you'll be seeing a little later when Ted is speaking. And there was agreement to go to a diplomatic conference. The General Assembly agreed to reconvene the original 2000 diplomatic conference for 2012 in Beijing. And that was the starting point for the negotiation. And there really was quite a narrow mandate for this particular diplomatic conference. I think mainly because the parties understood that if the whole text were opened up and a whole new negotiation were started, there'd be a chance that there really would not be agreement again. So there was a lot of discipline on the part of all the participants. The 19 provisional articles from the 2000 Assembly plus the agreed article were adopted as the text to be sent to Beijing. However, of course, you can imagine that it would be very difficult to actually go to a diplomatic conference with no issues to discuss. And in fact, there were a number of issues left on the table, including several that were incorporated into agreed statements, many of which were raised by Brazil. So these were agreed statements, for example, to incorporate the principles of the TRIPS agreement, the competition policy there, to clarify the relationship with the WPPT, which we talked about just a minute ago. There was a desire to not have there be a direct incorporation of the WPPT or obligation to join the WPPT in order to join the Beijing Treaty on the part of some member states. Then there were requests to clarify and expand slightly the definition of performers, plus finally a request to clarify the relationship between limitations and exceptions and technological protection measures. And that was something that ended up also being handled in an agreed statement. So finally, the Beijing Treaty was adopted. It gives economic and moral rights to audiovisual performers. And in terms of the economic rights, there are rights of reproduction, distribution, rental, making available, and broadcasting and communication to the public. Looks a lot like the WPPT, although there are some significant differences we may get into later in the discussion. At this point, We were in Beijing celebrating the adoption of the treaty. It was really an amazing diplomatic conference. And now I will turn back to Alan to let others continue with the story of the Beijing Treaty.
Thank you, Michelle, for the introduction and overview of the legal backgrounds and history of Beijing Treaty. Now we have our second panelist, Mr. Ted Shapiro. And Ted is a partner with over 25 years experience who has Wiggin, Wiggin Brussels office. Is a recognized expert in international and European corporate law, assisting clients on issues related to policy, litigation, compliance, and commercial transactions. And his topic for today is an overview of discussions spanning 2000 to 2015, focusing on the deadlock and eventually resolution around the transfer of rights mechanism in Article 12. So Ted, it's your time.
Okay, thank you very much, Alan, and thanks very much to AIPPI for inviting me to participate in this panel. So as we've heard, the issue of updating the protection of audiovisual performances at the international level has actually been on the WIPO agenda for a very long time, going all the way back to 1996, as it was excluded from the Rome Convention, more or less as Michele explained, the TRIPS agreement and later the WPPT. An agreement over this related rights treaty, and related rights treaties can be difficult for some countries that have only the copyright tradition, has proven elusive, particularly with regard to as between the United States and the European Union on the issue of transfer. And actually, I prefer to refer to the issue broader than transfer and more about the consolidation of rights in the producer. And also specific issues around the way that the audiovisual sector, and I think we'll hear more about that, the way that it functions. For example, there were concerns around moral rights and a broad definition of a performer. So we heard that member states were finally able to reach a compromise on this transfer of rights or consolidation of rights issue. But by then, the negotiation was no longer just about the US and the EU. Many other member states were involved, and there were some broader issues that Michele alluded to, and we may discuss more. But back in 1996, audiovisual performances were actually meant to be included in the WPPT. Most member states were in favor of that, but the United States was opposed, in particular due to concerns expressed by the US film industry. And the US put forward a proposal for a mandatory rebuttable presumption of transfer of all of the performance rights to the producer. There was, however, no consensus on that, and it was ultimately decided to remove that issue. And as Michele mentioned, it was then postponed until 2000. Again, in 2000, there was a failure. The 19 articles were put on hold. But I'm going to talk a little bit about this transfer issue and what was happening behind the scenes that finally led us to this compromise. Even before the 2000 DIPCON, the Motion Picture Association of America and its member studios spent a lot of time negotiating with the Screen Actors Guild, the union representing audiovisual performers, to try to come up with a compromise that could form the basis of at least the US government's position at the diplomatic convention. Now, while the US film industry wanted to maintain recognition and protection for the US work made for hire doctrine, the MPAA stressed that it was not trying to export this system, they just wanted to protect it. And indeed, in its work, the US film industry and others noted the prevalence of presumptions of transfer in many other countries around the world, including Europe. At times, it seemed like the then European community was wary of anything that it perceived as perhaps strengthening the position of the US film industry. And as a result of its negotiations with the Screen Actors Guild, they put forward a rebuttable presumption of transfer that would not have covered moral rights, by the way. This ultimately became known as Alternative E in the 2000 debate. Now, despite the fact that most EU member states had presumptions of transfer in their law, and indeed at the EU level in the Rental Rights Directive, they were completely opposed to having it in the treaty. The French, in particular, were very opposed, and that is because French law actually had a stronger, irrebuttable presumption of transfer, which might have been called into question. 3 other alternatives were discussed in 2000. A so-called presumption of legitimation, which is based on the Berne Convention, an approach based on applicable law, and then silence. And silence was the biggest problem for some of the negotiators. Now, despite a lot of work and near agreement on the applicable law approach, we were unable to reach a consensus. And so we began this period between 2000 and 2012 where the issue remained on the agenda, and in the intervening works, there were informal negotiations, particularly in the United States between US performers and US producers, then more broadly, as Michele alluded, between the International Federation of Producers and the International Federation of Actors and key member states, all leading up to a 2011 WIPO Standing Committee. In fact, it is pretty likely that there would be no treaty today if it hadn't have been for the efforts of the US studios and the US performers to finally come up with an idea to counter this concern about silence, about having nothing in the treaty. And the compromise in Article 12 that you can see above was reached before the diplomatic convention even convened. And the main issues in 2012 were about these extraneous issues around some points that had been put forward by key developing countries. These nearly torpedoed the treaty, and they concerned a preamble and certain agreed statements that Michele mentioned. So what does Article 12 that we're now looking at on our screen actually cover? And what it really does is it leaves the issue of consolidation of rights to the member states, how to regulate the getting of all of the rights into the hands of the producer so that they can optimize financing, production, and exploitation of the production. It allows for a vesting, an initial vesting in the rights of the producer, a provision on irrebuttable presumption, a non-rebuttable presumption, or doing nothing, excuse me. In any event, before such transfers or consolidations can take place, the performer has to have consented to being in the performance. So Article 12 is really something that's much more than, the headline is transfer of rights, but it's really about something much more than transfer of rights. And it talks about how the exclusive rights that Michele referred to in Articles 7 to 11 can end up in the hands of the producer so that he can get on with, as I said, financing, producing, and exploiting the film. As we see, the language refers to original ownership by the producer of exclusive rights. That's like a vesting. It also refers to the rights for producers to exercise the exclusive rights. So that means there could have been some kind of transfer after the rights were initially vested in the performer. And we see that there's a lot of room for choice. The word may is so that contracting parties to the treaty can elect to not regulate this issue at all. But the key thing is that if there hadn't have been this provision, there was concern by many that it would rule out such national consolidation of rights provisions. And countries were keen to be able to keep their own systems for coming to a pragmatic approach to this issue. And we'll talk about that a little bit later in the presentation. As I said, in any event, the performer has to first consent to the fixation. Countries are allowed to require that that contracts be in writing. And the last part of Article 12, which was added later, provides that independent of any transfer of rights under Article 12, national laws or individual agreements, including collective bargaining agreements, may provide the performer with the right to receive royalties or equitable remuneration under the treaty. And this was quite key. This was added at the last minute at the insistence of Brazil. It was arguably not necessary, and of course is the subject now for a lot of debate in national implementations. This is not a requirement. So there you have, I think, a bit of the background over the fight that led to Article 12, and a little bit about what it is made up of. With that, I will yield the floor to the next speaker, and thank you very much for letting me participate.
Thank you, Ted. Thank you for Thank you, Ted. Thank you for the speech, and we may have more questions about Article 12 after we finish our panelist speech session. And our third panelist is Mr. Bradley Silver. Bradley Silver is Global Head of IP Policy at Netflix, where he focuses on policy advocacy and strategy to address impact of IP legislative and related developments on Netflix business. And prior to join Netflix, Bradley was Chief IP Counsel at Warner Media. And his topic for today is importance and impact of its flexible nature in the audiovisual production sector. So let's welcome Brad.
Thank you. Thanks very much. So Michele and Ted, thank you very much for the historical and factual overview of the treaty, because I think it's important to know all these things, particularly how the treaty came about, because the peculiar manner in which it was negotiated and adopted after that pause of 12 years, I think is very relevant to understanding its implications for implementation. For example, the deadlock in 2000 and the eventual resolution of that deadlock shines a light on the centrality of Article 12 and how far each of the interested stakeholders were prepared to bend in order to reach a compromise so that this treaty could actually come to fruition. Back in 2000, the promise of the internet was already clear, but by 2012, that vision was certainly in high definition, with a broader availability of high-speed internet access, bringing entertainment to millions of people around the world via streaming and downloading. And now we're here 8 years later, and the treaty is finally in force. And many of the producers who worked with the governments to help negotiate the treaty provisions are themselves evolving into increasingly digital-centric deliverers of content on a global basis. So this, of course, underlies the reason for the treaty itself, to update the rights of performers to ensure that they're fit for the digital age. And so it's more relevant than ever in the context of an increasingly global marketplace for audiovisual content. As we've heard, the treaty takes a deferential approach to national frameworks when it comes to the question of transfer or consolidation of rights. And a question you might have, which I'm not sure I'm going to give you the answer to, but maybe we can discuss it later, is given how important the consolidation of rights is to producers, that this is the very reason for their ability to negotiate, finance, exploit, distribute content. Why were they so open to accept a compromise solution, which really doesn't give any definition around what should happen, particularly in an international instrument? I think it's just something worth considering and wondering about, given how central that issue really is and how for so long that deadlock existed. And certainly a very delicate balance was struck in the results, in reaching the results. And so I want to talk about for the next few minutes about the question of this flexible compromise and the potential impact in the marketplace as different countries begin to implement the treaty itself. And I also want to note that at this juncture that these are all my opinions and views, and not representative of either my current employer Netflix or my prior employer Warner Media, where for which I was working when I attended the Beijing conference back in 2012. So 2012 is not the only area of flexibility of the treaty. There are other areas where governments can limit its application, but Article 12 is definitely the most important or significant area of its flexibilities. It's permissive, as Ted mentioned. It's not prescriptive. It really allows countries to determine how to manage the transfer, consolidation of rights in accordance with their particular legal tradition. And indeed, that was one of the goals, as Ted mentioned, to ensure that work for hire lived to fight another day, and that there was nothing in the treaty that might cast any doubt or shadow on whether or not work for hire was a legitimate means of transferring rights. And so in that sense, the compromise position in Article 12 certainly achieved that. But it's more of a blueprint or a roadmap than an obligation. Which is not to say that it's completely neutral in nature. As you saw on Ted's slides, there are specific routes that governments are suggested could be followed in terms of how the rights might be presumptively transferred and what the implications of those are. And Ted has explored them, so I won't go through them again here. But that ultimately leads us to the question is, well, what's a legislator to do? You have these very important rights, and then you have this pivotal position that requires, in order for the audiovisual industry to function, really, it requires some degree of definition or clarity, either in the law or at least in the marketplace for the business to function. So the answer to that question, I think, is going to depend very much, given the nature of the compromise, on the country that implements its provisions. Not just the legal framework of that country, but also the socio-political and economic factors that are present in that company. Countries which already recognize performers' rights along the lines that the treaty requires are going to be in a position to exceed without making many or any changes to the domestic laws. But that doesn't necessarily mean that when they decide to implement the treaty, that they won't still choose to provide performers with greater protections than the treaty already acquires. So with any legislative endeavor, there's always a risk of a result that might be unbalanced. So I'll measure just two examples of quite different countries that have reviewed the issue and come to quite different results, although neither of these countries have actually enacted anything yet, but they have looked very closely and come up with proposals for implementation of the treaty, and they do offer an indication of what's possible in some respects positive and in some respects negative. And I'm going to talk a little bit about the United States and South Africa. So at the time the treaty was concluded, that the informal US perspective was that very few, if any, changes were going to be necessary to US law in order to comply with the treaty. I might add that this view was generally shared amongst the representatives of US performers and producers, which may have accounted for why the risk to agreeing to the open-ended solution, that is Article 12, was viewed as a manageable one, because there was this idea of, well, at least in the US, we have our collective bargaining framework. We're all, working happily with each other, and we believe that performers' rights are largely recognized. And so this will really be an advancement for the international framework, but for us at home in the US, perhaps nothing much will really have to change. And indeed, in 2016, when the US took a step towards implementation, only a few changes were envisaged in the proposed legislation, specifically to extend protections against unauthorized fixations of performances to audiovisual performers. Now, these protections had already been in place in relation to music performers, and now they were proposed to be extended to audiovisual performers as well. And another important change, also consistent with the treaty, was a provision ensuring that any exceptions and limitations, including fair use, would apply to this new protection, and that there would be a time limitation on it, so that it wasn't seen as a perpetual protection against being able to exploit any performance, any fixation of performance. Notwithstanding these changes, the overall approach was really intended to maintain and not disrupt the existing marketplace for audiovisual production. And the question of remuneration was going to be left unaddressed in legislation, except in a couple of places relating to statutory remuneration rights for cable and satellite retransmission. Those were the exceptions rather than the rule. But really, it was the understanding was that there was no need to address these rights given the robust framework for collective bargaining that exists in the US. And indeed, that was the plan all along. But not all countries have robust collective bargaining frameworks. Many countries have stronger collective management frameworks, or neither of the two. And so what happens when a country like that decides to implement the treaty and looks at these obligations afresh? One of the places that has done that is South Africa, in its performers protection bills and copyright bills. Those bills cover a number of issues, not just the implementation of the Audiovisual Performance Treaty, but other WIPO treaties as well. It's a real buffet of issues that come up in those bills, which are not yet law and are being the subject of further scrutiny at the moment, having been sent back to Parliament by the President for constitutional questions. And we won't dwell on that, but I want to focus in on the questions around how those bills implement the Audiovisual Performers Treaty, or at least the beginnings of that. There's a lot about the bills that are a little bit unclear, but the provisions on the remuneration section essentially require the ongoing payment of royalties for performers for all instances of exploitation. And these cannot be departed from by written agreement. Now, there is a presumption in favor of the transfer of rights once a performer enters into a written agreement, but those rights, that presumption does not extend to remuneration rights. Remuneration rights are essentially preserved, subject to equitable remuneration or the ongoing payment of royalties for any types of exploitation that may follow. Now, the one important provision that I think is in the background in the Audiovisual Performance Treaty and is not always clear in national implementations is that these rights are not intended to apply to every single performer. There is a differentiation between performers whose contribution rises to a certain level and others who may just appear in the background as extras and are not considered to be beneficiaries of all of these rights. And if that were the case, then that would really grind things to a halt if that was the base of implementation. So South African proposals don't make that distinction. Extras are implicitly included as in the definition of performers, which is exceptionally broad. And so you have a framework which applies a remuneration obligation to a very, very broad range of performers, and also doesn't differentiate between the ability to pay, for example, a lump sum or an ongoing royalty, which is something, again, that the treaty is naturally silent on, given market practices may differ from country to country. But it certainly raises concerns and issues for producers, local producers who are accustomed to paying performers lump sums, and for whom many performers would like to receive that money up front, given producers undertake almost all of the risk for the project, and many of which do not reach any level of profitability, and so there would be no royalties to actually pay, since most of the time there are no profits. So countries that implement this need to very carefully consider the implications for their local markets and what frameworks exist or may be necessary before implementing these rights and before implementing the remuneration obligations. Collective frameworks exist in many countries, but they're not, as I said, ubiquitous. Performers are often, in most cases, not considered employees, and therefore certain countries like South Africa don't, as of yet, provide an adequate structure for that to be supported. So I'll just close by saying that the treaty has a great deal of promise to strengthen the economic rights of film actors and other performers. But whether the treaty can deliver on that promise is going to depend to a great extent on how it applies the treaty in one area where there is the most flexibility around Article 12. Thank you.
Okay, thank you, Brad, for a practical view from the audiovisual industry. And actually, we have our last panelist, Mr. Sanjay Tandon. And but unfortunately, due to the problem of power grid in his city, he may not able to meet us online this time. I'd like to represent him to overview his slides for this moment.
Alan, I see Sanjay is on.
Sanjay is on?
Yeah, he's on.
Alan, I'm here. Alan,
okay.
I'm here. Yeah, I am on. I'm on. I'm just on from my telephones. So probably let's keep the fingers crossed.
All right, allow me a 2 minutes to give you a introduction. And so let's welcome Mr. Sanjay Tandon, and he's CEO of Singers Association of India and of the Indian Singers Rights Association. And he has been in the industry for the past 30 years and is well known as one who started the movement of collective management of copyright in music in India. And his topic for today is a view of Beijing Treaty from the performer's perspective and based on Indian laws and the impact of Beijing Treaty in India. So welcome, Sanjay. It's your time.
Thank you, Alan. Thank you. And I'm sorry, can you see me first of all? Am I visible or am I audible only?
Yeah, I can see you.
Okay, can you hear me?
Yeah, I can hear you.
Great. Sorry about this, but I think the entire city of Mumbai in India is right now under a grid failure. So we don't have electricity since the morning 10 o'clock here in India. But I'm happy to have been able to log in through my telephone. So I really regret not being able to come to in the best manner possible. Well, let me just quickly come to what I need to say on this subject. And as Ted and Bradley have already spoken to all of you, is as far as the Indian Copyright Act is concerned, you all should know that there was a comprehensive amendment to the Act in 2012, in June 2012, and that literally strengthened the rights of the performers in India. And with the result that if you see the Act as it stands today, post 2012, it literally has put into operation, has inculcated most of the features of the Beijing Treaty. So we can say we are at least the Beijing Treaty compliant as far as incorporating the provisions within our law. In the sense, first, an exclusive rights have been given to the performers. And performers are defined to mean actors, singers, dancers, and musicians. So all these people have been given this exclusive right that have been given to the performers, which is called a special right under the Indian Copyright Act, under Section 38A of the Copyright Act. In addition to these economic rights, the exclusive rights, they've also been granted moral rights. And performers, including actors, singers, dancers, musicians, have been given this right. Of course, there is a reservation that has been made in the definition itself, where the extras or persons who have an incidental nature of their engagement with the performance are not considered to be performers. So that's again one of the exceptions that have been carved out to give rights to the performers of audiovisual. Next slide, Alan. Hello. Yeah. Further, an exclusive right to receive royalty has also been carved into the act. So irrespective of the transfer of rights, transfer of the exclusive rights, performers in India are entitled to the right to receive royalty. Of course, it's also said that once the performer has by written agreement consented to the incorporation of his performance in the cinematograph film, then he cannot object to the enjoyment of the film, that particular film, of the rights in that particular film. That he cannot object. But other than that particular cinematograph film, he is entitled even to the rights of the exclusive rights, the exclusive economic rights, of course, provided there is a written agreement in place. However, irrespective of the transfer of all the rights that he may have, the economic rights that have been given to him, irrespective of the transfer of 100% of the rights, the performer in India is still entitled to the right to receive remuneration. So these are the things that have already been incorporated within the Copyright Act, which takes care of many of the items that Brad and Ted talked about, Article 12 of the Beijing Treaty. So this is the way in which India has tackled this aspect, even as way back as in 2012. And of course, as I said earlier, their performers are also being granted the moral rights to do this thing. The next slide, please. And here it is. So the performer is defined to mean the actor, singer, musician, dancer. Of course, there are other things, but those may be having some political repercussions because of acrobat and juggler and snake charmers and so on. But yes, as far as the cinematograph film is concerned, I think the main relevant people there are the actor, singer, musician, and dancers. And performers, as I told you, the definition excludes extras there from there on. So these two definitions are together, are for both audio visual as well as for the audio performers. So that is as far as the way in which India has done. Of course, the implementation is now under the process because the industry is impacted by this law, and therefore there are a lot of negotiations, discussions, litigations that are now going on. And I think that's why we are in a process of evolution, as far as I can say, with respect to the implementation and enforcement of the performers' rights in India, which is both WPPT compliant as well as the BAT compliant. So that's all that I would like to speak on this subject. And then I would like to open up the floor for for any questions, etc. Oh, I have one more slide, is it? That I've already spoken on, which means provided that in a cinematograph film, a person's performance is casual or incidental in nature and is in the normal course of the practice of the industry, is therefore not acknowledged anywhere or not acknowledged anywhere within the credits of the film, then of course he will not be treated as a performer. So this is the exception that's made to the definition of performers in the country. So back to you, Alan. Um, and we can, so I'm open for any question answers.
Thank you, Sanjay. Yeah. So after the speech from each panelist, let's go to the next session of the panel. So the Q&A session, and there's some suggested questions from panelists, and we're gonna make the internal discussion about those questions. And if you have any questions to any panelist, you could send your question to Q&A box, and we could check those questions and ask our panelists to give an answer. So the suggested questions for panel discussion, and the first one is besides the discussion and the contents, the cases we just discussed, and what other issues were difficult to reach consensus? So can we have Ted to start the answer to it?
Okay, yes. So of course, yeah, we have we have long dwelt now on Article 12 as being one of the principal areas that basically kept the treaty from being adopted for decades. But it wasn't a walk in the park for every other issue as well. We've alluded to the issue of the definition of performers and concerns that that might be overly broad. That proved to be difficult, but ultimately there was consensus on it. And you've just heard from Sanjay how while snake charmers are in, extras are out. So that includes the snakes, I think, but not the snake charmers. And another issue that I recall as being difficult was the full exclusive right of broadcasting and communication to the public for performers. Indeed, I recall the Indian government as being very much opposed to that. The broadcasting sector wasn't too excited about it either. In some respects, that provision goes further than the provision, the corresponding provision in the WPPT, which I believe is Article 15. But the compromise there was ultimately that although it is expressed in terms of a full exclusive right, member states retain the flexibility. It's another area of flexibility to create remuneration rights. And also to take reservations as to the extent to which they will provide that protection to performers from other countries. We always have to remember, although we talk about how an individual country implements an international treaty, international treaties are about giving protection to non-nationals. A country that agrees to the treaty agrees that they will now protect folks from other places. And finally, a third area that that I recall as being quite contentious, and I alluded to this in my opening speech, that one of the big focuses around this treaty, because it's so specific to the audiovisual sector, was the impact on the functioning of the audiovisual sector, on the impact of financing films, producing films, and ultimately distributing and exploiting them. And in that regard, one of the big issues was moral rights. How will granting moral rights protections at the international level to audiovisual performers, will that conflict with the way that producers then exploit these films? And this was a huge concern in the industry. Particularly elements of the industry from countries where such moral rights did not have the same level of recognition. Ultimately, there was a useful compromise in the Beijing Treaty that takes into account in the agreed statement to Article 5 that provides some relatively comprehensive kind of list of limitations and exclusions on the integrity right that comes from Article 5, as well as the patrimonial. And this kind of recognizes, or these limitations and exclusions recognizes, that things are going to happen to performances when they are adapted to different formats and things like that. And this agreed statement has given a lot of comfort to the industry going forward, and of course is something that industry likes to see replicated at the national level. So those are a few of the areas that I remember as being contentious beyond the transfer issue.
Mm-hmm. Okay, any other comments from other panelists?
I think we're going to get there maybe, so I don't want to preempt it, was, you know, the agreed statement on technological protection measures. Was certainly a bit of a hornet's nest. I don't know if we want to chat about that now, but I think I see it might be on the next slide. So I can wait to bring that up then, if you prefer, Alan.
Yeah. Our next question is how are countries implementing Article 12? So can which panelists could make the kickoff of this question? Michele?
Okay, I can certainly respond partially to this, although I'm not sure who posed the question. I would want to defer to them. But so because part of our function here is advising countries on implementation of the international treaties, excuse me, we do see what a lot of them are thinking about in this regard. Excuse me. And I would say there's a real variety from some countries that are going forward with the full range of rights, sorry, the full fixation provisions traditionally, to those that are requiring signature.
Take your time, Michele. Or actually, you know, in China, we cannot protect IP rights or neighboring rights pursuant to international treaty directly. So we need to convert the terms and conditions of an international treaty to the national legislation to protect neighboring rights. That is the rule in China. And so we make amendments of our national corporate law to strengthen the protection of performers' neighboring rights in China. So Michele, can you continue your?
Sorry, I feel like President Trump coughing away. I hope not for the same reason.
Yeah.
So yes, so some countries are just going with the traditional measures. A lot are adding a signature requirement. But there are some, I think number 0.3 is interesting, because where we see a lot of debate is around this question of receiving royalties or equitable remuneration for any use of the performance, what that means, what the limits of that are, and how that should be embodied in national law. And this is a place, I'm sure the others can comment as well, where we are seeing some differences in the approaches in different countries. It's also a place where we're seeing a lot of lobbying from different interested stakeholder organizations on how those provisions should be drafted, if they should be included in the law at all. So maybe the others would want to comment a little more on that from their perspective.
Yeah, go ahead, Bradley.
Well, I was just going to say that I think this seems to be something that's related to, but not necessarily a feature of implementation of the treaty, which is a press for unwaivable remuneration rights for both authors and performers, but certainly in relation to many countries that already, you know, protect authors' rights in a more robust fashion than performers' rights, where extension to performers is being discussed, that is a very hot topic at the moment, and definitely something that's high on the agenda of many collective management organizations and their representative organizations for for many of the same reasons. I think that the treaty came into place in the initially, which is that there are broader forms of exploitation, and that there's a question around whether or not performers are benefiting from those broader forms of exploitation. And also, I think you have a long history in many countries of broadcasters which are seeking to exploit works in digital and online, because that's where people are wanting to watch content, which have acquired many rights for very little in the past, and have and then performers are now seeing that content being exploited and wondering why they are not entitled to any additional remuneration, or it's fomenting, I think, marketplace practices that took place at a time where there was probably a lot less competition in the market as well. So right now, I think the competition in marketplace is much more robust, and performers are in a much better position in relation to content that's being produced at the moment, which is being used to on streaming services and the like. But this is coming up even when the Audiovisual Treaty isn't the focus of an implementation, such as in Europe. But certainly it would be a question that would come up during the Audiovisual Performers implementation as well, and has.
Yeah, I mean, if I might just add, so of course, Article 12.3 does not require, as I mentioned before, that you deal with any of these issues directly in your national law, but has, as Bradley alluded, and Sanjay gave an example, of course, it comes up independently of implementation sometimes of the treaty, but also sometimes along with the treaty. And the issues that can be difficult for let's say for companies that distribute all over the world, and they reach an agreement in one country and they agree to pay, for example, residuals, another sort of term for royalties, on a worldwide basis. And they pay out those royalties for exploitations wherever those exploitations occur. But then in another country, a local collective management organization may be exercising a remuneration right against the users of that content, and another payment is exacted, and that can cause difficulties. So it's trying to figure out a way to ensure that performers are equitably remunerated, but with some flexibility. This is never an argument about whether performers should be paid. It is always an argument about how they should be paid. And the question comes up in the Indian implementation: how is the remuneration that is required in the legislation actually collected in practice? Can it be through contract directly between the producers and the performers, or between unions and the producers, or is it only something that is subject to mandatory collective licensing or administration? And these are discussions that are playing out in many, many other countries, as Bradley alluded to. At the EU level, there is a requirement for remuneration, but countries are left room to decide as to how to do that. And there is recognition in the recent directive at the European Union level for collective bargaining agreements to fill in that place, but also other ways. Specific mention of mandatory collective licensing or statutory remuneration rights was not included in the EU level legislation, but it's certainly coming up in the debates in some member states.
Okay, I didn't see questions from the Q&A box, so we continue our suggested questions. And the third question is, what other challenges are there for national implementations? Do you have any further comments on this question? So can we have Sanjay? Is he online?
Looks like we lost him.
Okay. So Anna Palace would like to answer this question.
Yeah, I mean, I think that we've discussed quite we're sort of jumping around a little bit. We've discussed quite a lot of the other challenges, dealing with questions about whether there should be signature, dealing with the questions of prefixation and post-fixation. Bradley alluded to how the U.S. was dealing with adding prefixation rights in the so-called anti-bootlegging statutes that applied for audio to audiovisual performers, and some of these concepts that are difficult in countries that are not related rights countries. But we also had, and I think Bradley was starting to refer to this before, we also had back in 2011, right before we went to the 2012 diplomatic convention, Brazil and a few other major developing countries, when they lost the argument, and Michele referred to it, that the whole treaty should be reopened, basically, because everything in the world has changed since the 1996 treaties, and performers, for audiovisual performers, we're going to do it all differently. They lost that argument, but they did, because as Michele suggested, if it had been reopened, there wouldn't be a treaty today. They lost that argument, but they did win the argument that several issues needed to be looked at. And these were sort of what we call development agenda type issues. And there is recognition for these issues in the preamble. Now, whether member states have to deal with this when implementing the directive, the treaty, is for their appreciation. There are questions around the relationship between other treaties, which I would have argued was clear already. Although there was this added bit that Michele mentioned about, well, we're not going to tie the two. So if we want to implement Beijing before the WPPT, we will. If we want to not implement anything, we won't. If we want to implement exceptions before we even create exclusive rights, we will. And another issue that had emerged over the years was this difficult issue between the relationship of technological measures and exceptions. A long-standing argument that if you apply technological measures, you will kill off exceptions and there will be a threat to democracy, and we need to deal with this. And that was an issue that had been dealt with in many national implementations through various mechanisms, but was one that was added, I think, to the negotiations in 2012 and dealt with in an agreed statement. That talks about Articles 13 and 15. One of those is the three-step test, and one of those is the legal protection of technological measures. And basically, the agreed statement explains how member states can put in place mechanisms, but the mechanisms still have to function in compliance with providing legal protection. You're not going to give relief to exceptions that go beyond the three-step test. And what we see around the world is a variety of approaches to how people deal with this issue. You have mediation, you have the courts can deal with these issues. In some countries, you have self-help, which can undermine the legal protection of technological measures sometimes. But this is still a contentious issue around the world, but probably less so than it was before. In some ways, I think we've gotten on with this. There was a little bit of debate around technological measures in the recent digital single market copyright directive in the EU, but nothing really on the scale that we had seen back in 2001. So these are some of the other challenges, but I don't think that they have been as big in the context of Beijing as they have been in the past.
Mm-hmm.
Yeah,
Okay.
I would just add that we had 2 weeks to fill of negotiations, and there weren't any actual provisions that needed to be negotiated. It was really just the formality of adopting Article 12, which had already been agreed, and then a number of agreed statements. So I think there was almost a bit of a concern that if you looked long enough and hard enough, you would find more agreed statements to tinker with. And the wording of agreed statement 10 in relation to the technological protection measures, I think, was probably one of the single biggest focuses of the discussions, and potentially of concern, because I think for rights holders, the TPM provision in other treaties is considered a gold standard high watermark of protection in the international copyright framework, recognizing the importance of DRM, and it doesn't address directly the interaction between exceptions and limitations and digital rights management, which countries have done since then in their implementation in different ways. So the US with its triennial rulemaking that authorizes limited exceptions for 3-year periods, where there's a certain burden to show that the digital rights management measures prevent the enjoyment of a work for which one would otherwise be able to using an exception or limitation. And then there's a balancing test. And then this provision refers to that in some ways, but also encompasses the EU approach, which is conditional on stakeholders first voluntarily implementing measures to provide access, so that there's almost more of an intervention mechanism. So if you don't facilitate the enjoyment of exceptions, then governments can employ a mechanism to address the prevention of being able to enjoy those exceptions. So I think this statement actually strikes the right balance. It describes the regimes which already exist, and it also I think takes it even a step further by clarifying that one first has to have legal access to the work, which is an important element that is not always recognized in all national laws. And I think I have not seen any real world implications from this. I don't think that it has resulted in a weakening of protections at the national level, or that there's some use of this being made to say that, well, no, this alters the framework. I think it strikes the right balance, but there was a lot of contention around it.
Okay, thank you all, and let's go to the next question. What is the significance of the preamble recognizing the importance of the development agenda? Can we have Michele to share your idea about this?
Sure. And I'm sure others may have some other views as well, but in the interim between diplomatic conferences, WIPO had adopted an extensive development agenda that really affects all the work throughout the organization, and shows that there's a development orientation and context. And so despite the agreement that the treaty text was fixed, there was a strong movement among some member states that were very interested in also incorporating the development agenda into the work of the various standing committees to recognize this new context and the development agenda. And so as this was not something that really made sense as an agreed statement, because an agreed statement really relates directly to the technical article to which it's attached, it was developed as language in the preamble. And there's recalling the importance of the development agenda adopted in 2007, along with a number of other statements about other things that need to be kept in mind in terms of different kinds of development and the balance of the rights of performers and the larger public interest. This language was developed And perhaps, as the others alluded to, because we had a fair amount of time, there was a fair amount of discussion around this language, although ultimately it was adopted without any real difficulty. And certainly in implementation, some member states have wanted to refer to the development context and have done so without, as far as I can tell, any real difficulties in that regard. So, but it was really recognizing that this had been a milestone for the organization and that it should be captured in the introduction to the treaty. And I believe this was the first treaty that actually referenced the development agenda. So that was another way in which it was a historic treaty. I was thinking back when Brad was mentioning all the time that was available to the diplomatic conference, where the chair probably very wisely said, if everyone agreed by a certain date, then he would take everyone to the Great Wall for an excursion. So, and I know from talking to some friends on various delegations that they were like, all right, look, we're gonna agree anyway. Let's agree in time to go to the Great Wall. So that was a very wise move by the Chinese organizers. And I know that the people who went on that trip really found it like an amazing experience as well. So that just added another flavor to an element to that diplomatic conference. But yes, there were, there was a lot of time and there weren't terribly many issues. So certain provisions got a lot of discussion that in another context, for example, similar language in the Marrakesh Treaty, at that diplomatic conference, we really didn't spend a lot of time on it, possibly because there was a precedent from the Beijing Treaty, but also possibly because there was a very long list of other issues to actually be resolved at that conference. Thanks.
Okay, thank you, Michele. Any more comments from Ted and Brett about this?
Yeah, I mean, I guess I would agree with Michele. I mean, the most significant aspect of the reference to the development agenda is the fact that it's referred to, and that put it on the map. In terms of practical impact, what did it change about the treaty beyond reminding folks that when you put in place protections, think about development? And there's an argument behind that. I would argue that putting in place intellectual property protections is actually something that spurs development. It has been suggested by others that sometimes intellectual property rights hinder development. But I believe in the context of including it in the Audiovisual Performances Treaty, that it is a reference to how this can actually spur development. The folks that will benefit the most from this treaty are performers in countries where there was no protection in place previously, and having it there will help their industries develop, hopefully by also incorporating some flexibility. I've always been confused by the reference to the convention establishing the WIPO organization. I'm wondering if that is the right reference, but that's something for the historians.
So, Brett?
Yeah, I would just say that just to build on what Ted said, I think it was a feather in the cap of those delegations and countries that were promoting the development agenda, or at the forefront of the development agenda, to have it memorialized in an international treaty, which is really, for many years to come, in 100 years' time, people are going to be asking, "What's the development agenda?" In the Beijing Treaty. Like, let's go back and look at that, and and understand what it means. I think it was something that is very particular to a certain point in time, where the development agenda was at the forefront of WIPO's, on WIPO's agenda. It always has been, and it always will be in some form. But I think the reference there is about a particular movement within WIPO, a particular discussion that was happening about a need to see copyright through a development lens. And I think that having a reference to the development agenda in a treaty, which essentially follows the template of prior instruments like the WPPT and the WCT, is actually quite a strong reference to the ability for those systems to exist together, and be consistent with each other.
Okay, so we have 10 minutes left for this session. And according to our panelists, there's some articles we should pay more attention to, especially Article 1, 2, and 12, due to the time limit. And also we already discussed about the Article 1 related issues. How about we focus on Article 2, the definitions. And there's really some definitions like performers, like fixations, and also communication to the public. There's some to me there's some kind of conflict between those wordings and the Chinese law. So I'd like to know your ideas and your comments about what is exactly the word means, and how we explain, and how we treat the behavior like a snake charmers, or those TikTok users behaviors in China, or US. So
before we try to answer your question, Alan, maybe I could ask you a question. What is the conflict that you see in Chinese law?
Actually, when we say that performers, normally we say that the performers used to those professional performers. But there's more and more, individual, users, or they do the live streaming, and they do those live broadcasting by themselves. So we need to expand the definition of performers, and also for fixation. When you say fixation, that means a tangible mode of a content, or including any digital mode, or any online live streaming, without a fixed product of audio video content. And that is something happened in the practical case in China between lawyers, judges, and the industries.
Yeah, I don't know whether it helps. I mean, and the question of when does a TikTok performer who has literally tens of millions of followers become a performer under this treaty is an interesting one. There some background, to the extent that it's useful, if I remember correctly, really relates to the agreed statement to the definition of performers, which was the subject of further discussion in 2012. And in particular, to your point, it has the added language where includes those who perform a literary or artistic work that is created, so where you're performing a script, but also something that is first fixed in the course of a performance. And if I recall correctly, and that was basically meant to deal with, I believe it was the Indians that were saying we had all these dancers and snake charmers that are essentially ad-libbing. They are improvising during the course of the fixation, and that merits protection in their view. And that's why that language was added. I think, if I recall correctly, having discussions around that, even in the run-up to the 2012. And that example has some relevance, I think, to what you were just saying, that, it gets fixed as it's getting made.
Mm-hmm. So, Brett, do you have any comments?
No, I mean, I agree. I agree with what Ted said. I think in relation to the fixation question and whether or not that is required for it to be fixed in some tangible medium, I think the one area where I guess there may be some future question is the reproduced or communicated through a device. I think their language is older than the treaty. Their language is pre-existing, and I'm sure there will come a day in the not too distant future where you won't need a device to communicate a work. It will just be in some kind of perhaps through your neural pathways or some I think at some point you will still need an implant in your head or something that will qualify as a device. So maybe we're still a ways away from that, but I think
I hope you're not giving away any future plans of Netflix there.
right. Yeah, who knows? But I think that's words like device are a bit, maybe will be arcane one day, but I think the language certainly is broad enough to encompass any any kind of medium that enables communication, which would include the internet or something that doesn't require an existence of a tangible copy of a fixation. I think at some level a fixation will occur that will enable the communication to take place, because something has to be fixed. It's not going to be ephemeral entirely, but I think it's quite broad.
Mm-hmm. So Michele,
just take yourself off mute.
Yeah. Got it. Yes, I agree, and on the fixation, I thought the law had been clarified in most jurisdictions that digital fixation was sufficient to meet the requirement, and that it is not necessary to, for example, transfer a digital file to a physical format in order to get protection for it. On the performers, I also recall that India was one of the prime movers of some expansion here with regard to the works that are first fixed in the course of the performance, and it was with respect to Indian traditional dancers. Another element here that actually a lot of member states, when they are incorporating this provision in their legislation, want to pay attention to is the incorporation of expressions of folklore, or what we now refer to as traditional cultural expressions. A lot of countries are quite interested in protecting fixations of those works in their laws and when incorporating the Beijing Treaty. So we've seen a lot of activity around that now. Having the words in the law doesn't necessarily mean that anything happens with that yet. So we're at the early stages of seeing how that will actually be implemented and what use it will be put to in the national legal systems.
Yes, to me, as far as I know, that the Chinese government is going to consider to amend the corporate law to apply to the production of liberal rights of performers of folklore or folk arts. Mm-hmm. That is normally not within the scope of corporate production in China before. Mm-hmm. That is one good issue. Okay, we have one question finally from the Q&A box. So it's from Lena. If I understand correctly, the assignment of the performance right is some key provisions of the Beijing Treaty. I am curious, what does the treaty say about this, and how is the reality in your respective country? That is a question. So, Ted?
Well, this is really the issue of Article 12.
Yeah.
And Article 12, as we described it before, and I guess it's good that we can kind of go out where we came in. allows for various different methods of consolidating rights in the producer. And Article 12 allows for a presumption of assignment, a rebuttable presumption, an irrebuttable presumption, an initial vesting of the rights. And it is indeed a key provision, but a lot of flexibility, as we've discussed, for member states. The reality in most countries is that there is a provision of some kind that deals with this issue, whether it is work made for hire in the United States, irrebuttable presumptions for performers in the rental rights directive of the EU, presumptions of legitimation, which seemed to be a little bit what the case was in India, that these exist around the world. And in countries where they don't necessarily have specific mechanisms in their laws, they generally have a great deal of contractual freedom that allow the parties to come up with solutions. This is not something you have to do, but most contracting parties and most copyright systems around the world do deal with it in one manner or another.
Mm-hmm. So, Brett?
I have nothing further to add to that.
Okay. Michele?
So I would say this is one of the areas where, when we're working with member states to implement the law, that it's quite important. And in general, it's important for countries. There are a lot of countries, including developing countries, that have thriving audiovisual industries, but in order to make those a viable contributor to the economy and to allow the artists and the creators and everyone involved in the value chain to actually monetize and then make more films and finance further films and develop the industry further, it's really important to have this underlying legal framework. So we're frequently working with member states who have targeted the audiovisual industry as, for example, something very important for their future, for their economic future, for an economic development plan, to make sure that they do get all of these provisions into their laws so that they have that framework and can really start allowing the creators, the producers, everyone in that value chain to see some results and then ultimately to have a strong contribution to the local economies. So it really all ties to building thriving film industries around the world in countries at all different levels of economic development.
Thank you, Michele. I think the time is up, and I believe each country have their own highlights and their own industry practice. And the Beijing Treaty just set up a bridge of consensus for each country. And we will try to give a correct understanding of the legal resources or the right understanding of the world fundamental definitions of rights or expressions of a performance. I think that would be a quite good treaty, and it's gonna be more practical to do international licensing and transfer of rights. So thank you all. Thank our dear panelists, Ted, Brett, Michele, and Sanjay. And we wish everyone have a good day. And Brett, you could have a good sleep then.
Thank you.
Okay.
Bye, everyone. Thanks very much.
Thank you very much.
Bye.
Bye-bye.
Bye-bye. Thank you for your time.